Every country has courts, but legal systems differ in fundamental ways. So let's understand the distinctive character of the American legal system because its design shapes how every case unfolds. The first defining feature is that the American system is adversarial. In an adversarial system, the truth is supposed to emerge from a contest between two opposing parties, each presenting its strongest case before a neutral judge or jury. The judge is essentially a referee, managing the proceeding and ruling on legal questions rather than an active investigator. This is quite different from the inquisitorial system common in much of continental Europe, where the judge takes an active role in investigating the facts and directing the inquiry. In the American model, the lawyers drive the process, and the neutral decision maker weighs what each side produces. The theory is that vigorous advocacy on both sides will surface the relevant facts and arguments. The second defining feature is that the American system is unusually litigious. Americans go to court a lot. Compared to most other societies, the United States resolves an enormous range of disputes through formal litigation rather than through informal mediation, administrative processes, or social mechanisms. This litigiousness has consequences. It makes lawyers central players in American public life. It makes courts a primary arena for resolving social conflicts, and it means that many policy questions that other countries settle through legislation get fought out, at least in part through lawsuits. One implication worth dwelling on: because the system depends on advocacy, the quality of legal representation matters enormously. A party with skilled, well-resourced lawyers has real advantages over a party without them. We saw this concern in the criminal context with the right to counsel. It applies in civil litigation too, where access to competent representation can determine outcomes. And this connects to a theme the textbook will press hard in the next section: the gap between the promise of equal justice under law, the words carved above the entrance to the Supreme Court itself, and the reality of how the system actually treats different people. The adversarial, litigious design is, in principle, neutral. But a system that depends on each party mounting an effective case will inevitably produce unequal results when the parties have unequal resources. So, as we celebrate the elegance of the adversarial model, we also have to ask honestly, equal justice for whom? That question carries us directly into the chapter's most uncomfortable material: